Hello friends, so as you know, I've already been posting about this new decision that came around in the Ninth Circuit called Ramirez v. Brown. It happened March 31st, 2017. I believe it's very important for our community to know, especially because we have a lot of people from the countries of TPS that are in our community, including Nicaragua, Honduras, El Salvador. So if you have any friends that you know or family members that are under TPS, this might be a good video to share with them so they can get a lot of information. So what Ramirez v. Brown states is that anybody who has had a designation of TPS, which is called temporary protective status from their countries, will be considered now a legal admission or a lawful entry. This is very important for those people who have immediate relatives. Immediate relatives are only spouses who are United States citizens and children over the age of 21 who are born in the United States. This means if you have TPS and you have one of those relationships, you can petition to become a green card holder within the United States. Now, a lot of people make their decision to become a green card holder based on that, based on whether they can stay in the United States or whether they would need to leave abroad and request for a pardon to leave the country. So this comes at a great time. So a lot of people have TPS. A lot of our TPS holders have now been part of our community for more than 21 years. So most likely, most of them have a child who's over the age of 21. The reason why this is so important is not because this is a new topic. It's because most people who have had TPS and have not been considered to have a legal entry, we attorneys have figured out a way to get them this legal entry by advance parole. So anybody who's come to visit me who's had TPS and has had one of these relationships prior to Ramirez v. Brown, we've suggested them to do an advance parole. Advance parole is a request to leave the country under a permit for a specific reason, either humanitarian, under an emergency, or for work or school purposes, to leave the country and come back. Now, the coming back gives you a legal entry because they put a stamp on your passport and an officer needs to inspect you in order to allow you back into the country. So this has been the way that immigration attorneys have made it possible for people who have TPS to petition for their green card within the United States. Now, what this Ramirez v. Brown does is immigration attorneys no longer need to suggest the advance parole because TPS alone gives you a legal entry or a lawful admission. So this is huge. Again, it could cover a lot of people. Some of the questions that I've been getting is, my spouse is a green card holder. Can that spouse petition for me? And the question could be yes or no. But most likely you will need that immediate relative, so you will need a spouse who is already a United States citizen. So the easy fix here would be to ask your spouse to become a citizen, depending on whether they have the years sufficient to petition for the citizenship, and that's usually 5 years. Now, that's where a lot of the problems arise because some of our spouses cannot become a citizen based on the years that they've been in the United States, based on the fact that they don't speak the language, or based on crimes. So that's very important for us to look into those questions and look to see if we can have an answer on some. I know that I have some personal family members who are going through that, who they have TPS, but their spouses can't become a citizen due to one of those factors that I've stated. So that's one of the questions that I'm getting. The second one is for those people who have had deportation orders previously or who have been granted voluntary departure orders from the judge and have never left. This typically happens to people who have TPS because of just the countries that have it, which Nicaragua, Honduras, and El Salvador. Usually they come into the country and they're placed in immigration proceedings, and most likely A, they have the deportation order, or B, they have the voluntary departure order. So it's going to be very important for those people that have that those orders to still petition the court to reopen their proceedings. So there's one other step after Ramirez v. Brown that we need to do in order to get that green card. So there's a lot of lingering still questions that need to be addressed before we can petition for it. Now, Ramirez v. Brown, I believe, will be published soon. And if you're interested, I will put all the facts there so you can see where your case falls in relation to Ramirez v. Brown. For more updates on this and other questions that I will be getting within the next few weeks, I will be posting. If you have any questions, I suggest that you ask them in the comment box, and I will try to answer as many as I can. But I definitely suggest that if you have a family member or you have a friend with TPS, this would be a good time, a good marker, even if you don't have that immediate relative, to do a consultation to see where your case can lead up to. This is a great time to alert some of our friends to be very proactive with their immigration status. And for more updates, again, you can click on any of the links that we have on social media. Thank you.